slide for this round that I will quickly go through. The info slide is, there are legal rules that limit how law enforcement may obtain evidence, such as requirements to obtain a search warrant before conducting searches of a property, prohibiting certain types of surveillance, or requiring police officers to be able to justify conducting a search of someone's person. Evidence gathered in breach of these rules is considered improperly obtained and is generally inadmissible in court. However, in many countries, courts may still allow such evidence in circumstances where a serious crime is alleged, and excluding the evidence would significantly harm the prosecution case. The motion for round 7 is, this House believes that courts should never allow improperly obtained evidence to be used in criminal trials. Cool. Speaking times are 7 to 8 minutes. You'll get 1 clap at 1 minute, 1 clap at 7 minutes, 2 claps at 8 minutes. Replies are half of that, so 3 to 4 minutes. That's 1 clap at 3, 2 at 4. Cool. Do we have any further questions? Beautiful. Let's get started. Without further ado, I invite up the first speaker of the affirmative team to start out this afternoon's debate.
When you impede on the right to privacy, you strip an individual of their humanity because they no longer have choice. You strip a potentially innocent person of their dignity. We could never stand for this. 3 things in my speech today. Firstly, I'm going to do some setups. Secondly, I'm going to prove a principle of privacy and choice. And lastly, on profiling and an unchecked police power. So firstly, in terms of some setup. 1, what are the instances where improperly obtained evidence is allowed to be used in court? Firstly, this probably doesn't apply to the blatantly obvious cases where an offender is obviously guilty. That is because it is quite easy to find evidence that is properly obtained in these instances. And in these cases, you can obtain search warrants legally. For example, you have really good forensic technology that is incredibly advanced. We can do things like trace the DNA and find the initial evidence, or you have like video evidence and a lot of clues, which means that you never actually need to use illegally obtained evidence in these court procedures anyways. What the setup does, it preemptively prevents side negating from claiming that this is a debate about this law only being used in a minority amount of cases. They cannot narrow the scope of this debate. But secondly, this debate is therefore about the cases where there is relatively low evidence that a person who is accused has committed crime, which is why legal search warrants is very difficult to obtain in the first place, which is why you have to illegally obtain this evidence in the first place. But even if you don't believe this framing, my principle stands independent of this. So now let's firstly talk about the principle of privacy and choice. 1, why do people inherently have a right to privacy? We'd say that it's because privacy grants you choice and agency, because it allows you to act in a way that is free from external judgment and scrutiny that clouds choice. Note here that the threat of surveillance from a state impedes on this because of the disproportionate power states hold over the civilians. The monopoly of force that you never consented to is an incredibly large amount of force that changes the sort of tipping point in the way in which you act upon your judgment, right? It is important that people are able to experience agency inherently, because the point in life is that you have to be able to express yourself. You have to live a dignified life, and you want to be able to respond to your environment, right? Because the right to choice is inherently tied to the right to life. That is why we abolished slavery. That is why we have legal protections over individuals' rights. That is why you have the procedure of the criminal justice system, and you do not just go out and shoot people who you think committed a crime, right? Okay, but secondly, we believe that the people are just inherently innocent until proven guilty. A, because you only restrict the rights of people in criminal justice system, and you only lock them up when you're able to prove guilt beyond reasonable doubt in the first place, right? This means then an unwarranted search and illegally obtaining information is a non-consensual violation of rights and human dignity, because you never consented to having your door busted down, you never consented to ICE raids that come in and strip you of your dignity and humiliate you in your own house. But B, because when you punish people and you take away their rights, whenever the court uses this information in any instance, right? Note how this principle applies to literally every single case of criminal justice system, because all cases before they get into court are not 100% certain in outcome. This means that this applies to literally every single case. This applies to all instances. You should weigh this incredibly highly. At the end of this, we'd say that we do not falsely punish people. It is incredibly important. 1, because by doing so, it undermines the the entire criminal justice system to actually deliver justice in a way in which people agree with, but two, it is just bad for public perception and the trust in the criminal justice system. Note here that the criminal justice system and the functionality of the system is inherently tied to ability of people to trust the system to bring justice, as opposed to people being Spider-Man and going out on the streets and delivering their own justice, right? We trust the system to actually have justice in the first place. But three, it is the idea that the justice system is transactional and proportional. It is why you have to decide a sentence proportional to the amount of crime someone has committed, which means that if you punish someone for something that they never actually did, or you never actually proved to beyond reasonable doubt, it is not principally just to punish these individuals by humiliating them in court, by questioning them with information that they were violated through the process of obtaining. I'll take a POI.
If these people are already allowed, if the court already allows to get search warrants, invade people's privacy, etc., for the purpose of finding evidence, why is it any different?
We'd say it's not allowed on outside the house, like read the motion. Okay, now that I'm going to talk about profiling and unchecked police power on both sides of the house. Firstly, police power should be checked and balanced. A, because the police and the criminal justice system are products of the state, and the state principally exists to protect people and reflect their wants and needs. But B, the state holds a monopoly of force against people, and this power should therefore not be used to oppress people, because people cannot fight back against the state. The state has guns, the state has tanks. You are just one individual, you are just like flesh and bones. It is very difficult for you to fight against the state, which means that the power should be checked and balanced. People have a lot less agency than the state. But firstly, the state has political incentives to be tough on crime, right, in order to do things like prove state power and signal a crime intolerance to the general public. And what this means is that, secondly, the types of people who get caught in criminal justice system tend to be incredibly vulnerable, right, tend to be minorities. And there are 4 reasons as to why this is true. A, because structurally, these people tend to be in poverty cycles, which just has like societal perceptions of crime that are like aligned with this. B, because they're just often around cycles of abuse, and there's very little mental health support and support systems for these individuals who tend to be disenfranchised. C, because these individuals have low abilities to defend themselves in court. They have poor access to things like public defendants and attorneys notoriously suck because they're underpaid and because they have to constantly get through a lot of cases, right? But D, because these individuals in low-income areas are inherently over-policed, which we think that when you have like this unwarranted evidence, it is often obtained through the lens of minorities, is often attained within these specific neighborhoods. What does this mean when courts allow improperly obtained evidence in some court instances? 1, you increase the legal ability for the state to impede upon minority communities. That itself is inherently principally abhorrent. But 2, you have more over-policing that can be publicly justified, right? This looks like having ICE raids and dawn raids, the unwarranted searches against minority communities that are incredibly, incredibly damaging because you strip these individuals of their dignity. You strip these individuals of their inherent power, and the state undermines them as human beings. This looks like, even if you don't believe that this happens to the scale of things like ICE raids and dawn raids, even though they are incredibly common around the world because of this policy, this also just looks like police individually impeding on like marginally more minorities. It looks like you're busting down more doors. Even if it's not on the scale of mass raids, you should believe that it happens. It is incredibly damaging for these minority communities. But thirdly, like specifically in minority communities, it just worsens the disparity between these individuals and the state, right? And note here the criminal justice system is already inherently traumatic for minorities. And this gets worse because as opposed, like now you're not only being cross-examined and questioned about your abuse, now you have evidence that was illegally obtained against you that makes it even more traumatic for minorities who have very little support in the criminal justice system. That is inherently harmful, not just for minorities, but for everyone in which this evidence is put onto court, because it is never certain that this person committed crime to 100%, right? But fourthly, this is really checked and balanced by your average voter, because people just oftentimes do not empathize with potential criminals, right? The general public oftentimes dehumanizes these individuals, and there's very little support for criminals going through the criminal justice system because the general public has a preference for like safety over the like protection of criminals, because they oftentimes just are not able to like empathize with them at all. At the end of this point, even if they claim that you get more people prosecuted, it is just not sufficient for them to win on. This is preemptive because we care about the delivery of justice being done in a proper way. That is why we do not preemptively arrest people. This means that even if justice takes longer, it is still more just because it means that the people who are going through the system have a better experience. But B, we do not want to falsely punish people. It is traumatic. Let's not strip people of their basic human dignity.
Thank you, guys.
We believe in a world in which one of your family members has been murdered. We believe in a world in which you have to deal with the grief, you have to deal with all the trauma that is associated with that. We believe in that world that we should not stand, that we stand for getting the retribution, for getting the rectification of things that have happened and of the wrongs that have been committed to you through whatever means are necessary. That is what we stand for in this debate, and we stand for greater public safety, that it never happens again. 4 things for me to do for you in my speech today. 1, a point about setup, then onto some preliminary rebuttal about what we believe this principle doesn't stand for, and then onto my 2 substantive points. 1, about how you just get, in general, better public safety, and then, secondly, a principle on the courts and its purpose. So, firstly, a point about setup. What do we stand for this being? What do we stand for this looking like? Firstly, we believe we stand for this being extreme and really violent crimes. We explain particularly why this will be the case, but we also believe that these tend to be in the cases in which you have extreme bodily harm, things like terrorism, things like sexual assault, things like murder having been committed. Secondly, we believe that the evidence often looks like, for example, a knife or murder weapon that has been obtained through an illegal search of property, or, for example, and we also believe, noting here what we hear in the info slide, or what we read in the info slide, that these are often very significantly important or key pieces of evidence in a case, and we'll also prove to you that right now. So why do we importantly believe that the evidence and that this system is not going to be abused? Why do we believe it is used in rare occasions? I believe, firstly, we believe that police just inherently want trials to be successful. Why is this? 1, because, if a trial is successful, it reflects well on you. If a trial is bad, it probably reflects badly on you as a police officer. B, we believe that you want a case to be good, you want the case to be successful because you work very hard at the case, you often work very hard in the case, and then C, you often probably just have like a principle that you want the criminal to be behind bars if you believe this person is guilty. We believe that in this scenario you believe the person is guilty, you believe the evidence that you have means this person is guilty, and D, you also likely have some principles and belief in the law, so you also likely do not believe that you should be abusing the law at every single turn. What does it mean? It means that you still have the chance, that means that there's still a chance that this evidence does not work, that it is thrown out by a court in our side of the house, which means that you go to this case often with this key piece of evidence and you're not abusing the system a lot, and you're pursuing other avenues before that and first. Secondly, we just believe the department doesn't want this to happen as well for very similar reasons. If an officer is using this regularly, we believe, firstly, you want your case to be successful, and B, you're just very open to lawsuits for this happening as well. We believe you fire an officer who does this quite often. I'll take a point. We don't punish innocent people because we believe they're innocent. We believe in a world in which we have a key piece of evidence that we believe that someone is guilty, and that we get rectification for the harm that they've committed to people. That is far more significant. That is what we should care about in this debate. We believe, and that actually very likely brings me on to my rebuttal to the principal point that we get. We believe at the point at which significant harm has been done, extreme harm has been done, where there has been direct, terrorism, where there has been sexual assault, where there has been murder committed, that this overrides the instances that we want to apply this principle. I think firstly, we'll see it later when I get to my principle on the courts, that is how we also believe it doesn't apply, and we see more interest in pumps about this. Firstly, inherently, we believe that the government has felt it's one of its primary roles in protecting citizens and protecting its people. We believe in that case, its next priority should be helping to protect and to fulfill their victims' families as well. We believe, so how do we do this? And I think far more importantly, in the tangible aspects that we get about public safety. I think in this argument, I'll prove to you that the ability to use this improperly attained evidence in the extreme, these high damage scenarios will protect the public. And then why is it important? Because again, I think we tell you about the scale of the damage here that is far more likely to outweigh the principle that we get from the affirming team, just simply and inherently because we see the tangible harms that are committed to every single person that is involved in this and the trauma that you get. Why is this? So how do we get greater public safety? Firstly, we just believe that this evidence is key evidence that needs to be used. I think we give you and set up these reasons why this is used rarely, but also this is like, these are reasons as to why this is also used rationally, and the evidence that you get is likely to be key, is likely to be important, is likely to be, logical when you use this. We believe that you cannot get this evidence any other way because of this. We believe that the core piece, this evidence that you get is the core piece of evidence to put a murderer behind bars. We believe, therefore, because this evidence is so vital, when we use it, we are far more likely just to get criminals behind bars. Secondly, we believe there's an element of deterrence. We believe criminals often use loopholes, often use these use loopholes that are inherent in the law. We believe A, good lawyers enable them to do so. You make evidence seem illegal with the way you got it. We believe that there are ways to do this. And B, this is often because the law has so many loopholes. The law tries to cover so many different scenarios, it cannot possibly apply all of them. So in applying the same basic principles, you're never able to cover all these scenarios, so loopholes do exist. And then we believe ultimately that the criminals can no longer hide behind these things now, hide behind these loopholes. They can no longer commit harm, as particularly these calculating and extreme cases such as a serial killer, for example. 3, we just believe the retribution does not occur, that you get to witnesses. We believe criminals that do not get convicted often will have an incentive to go after witnesses that have trialed against them, or victims or victims' families as well. Why is this? Because A, they might hold a grudge. B, because they want to set a precedent that you should not testify me ever again. And then C, you also want to clear up the case and just get rid of witnesses that saw you do something. Really, the aim of this for criminals when they try and get retribution is that they try to kill these people. Witness protection doesn't really apply in cases except for an organized crime. We believe the outcomes of this are quite obvious. What are these outcomes? Really, on this outcome of that protection of victims and witnesses, we believe in a world we should 100% prioritize the victims and the witnesses that have taken an immense emotional toll to stand in front of a court, tell them about an experience they've seen that has been so immensely traumatic. They might have seen their greatest family, their loved one murdered in front of their very eyes. They have to get in front of a court, point to the man and say, this is the man that did this. We believe in a world in which that person is put under harm, put under threat. There's significant harm attributed to them. We don't get this harm when it comes out after. Secondly, we just believe we get greater public safety as a whole. We believe that this is so much more impactful when people feel they're safe, and we believe these things. Okay, onto the principle about the courts. What do we believe the principle of the court is? We believe it is essentially to consider all the evidence that you have at your disposal to get justice, to put a guilty party behind bars, and to get the best action and outcome because of this. What do we believe the purpose of the courts generally are? We believe, one, you also see it's interacting with law. We believe the government also does this. We believe secondly, it's protecting the public, which the police often does. We believe the third and final thing that is unique to the laws, with the courts, and the courts must apply, is mainly this unique purpose and excuses and the primary function for the courts to persecute and to get better outcomes for victims after crime has been committed, and to consider all the evidence as they do this. And we use a variety of interest and pumps in order to get this. Firstly, we allow processes and civil processes to be disrupted all the time. We see this, for example, in censoring the media, so jurors do not get unduly affected if a famous person has is in trial or is being trialed for something. We believe we suspend a whole lot of other privileges, a whole lot of other things, such as privacy in this case, or such as, for example, the right to freedom of speech. We suspend these things when we believe it's important that you have, for example, when it's important that we get the best outcome, and that the outcomes and the evidence that you get is unimpeached and unbiased. Really very similarly, for example, when someone gets up to witness or testify in court, for example, we force them to tell the truth. You swear an oath to tell the truth in court. You can essentially get asked anything, you must tell the truth about this. You violate your privacy in order to go behind, in order to get the best evidence and get the best outcome. We believe this applies in this case. We believe in this case we get the same thing, in which we have evidence that's important to be used. In order to get the best outcome, we should not impeach that ability to get the best outcome just because someone has made a mistake or got evidence improperly. The evidence still holds value in itself. That is why we evaluate. That is why I value this, and that is why I'm proud to negate.
The thing that the opposition team fails to recognize is that the principle of agency, the principle to decide the course of your own life free from coercion from the state, is prior to any other principle that they can claim. The principle of feeling safe in your daily life is a prerequisite for even having trust in the legal system that they claim brings you catharsis and brings you justice. That is what they fail to recognize. A couple things in this speech. Firstly, I'm going to respond to their POI. Secondly, I'm going to talk about how this is actually going to look and be used. Then I'm going to do my split, and then I'm going to talk about all different points they bring up about getting criminals in prison, public safety. Okay, firstly, then I'm going to do a quick response to their POI, because they tell you that search warrants are already allowed by the court, and therefore it's like a very marginal change, right, in terms of the principle. I want to note here that this is like very, very different. Why are search warrants so different? One, the court has to allow search warrants. This means that search warrants are inherently part of the legal system. They have to go through these processes. This means that it is transactional within the legal system, because the court deems that there's a justified reason, that you have created a justified probable cause that is decent enough to grant that search warrant, right? That means that in keeping with the legal system, that is incredibly different from this. But then B, the thing is with search warrants is that you have to see a search warrant before they come in. You have the right to ask for the search warrant, you have the right to ask for the reason behind the search warrant, you have the right to ask what they're allowed to do and what they're not allowed to do. They might try to claim that this is marginal. This is incredibly impactful. This is the difference between a police officer asking to come inside your home, knocking and showing them your badge, versus a thug walking into your house if you were somebody who doesn't know what's going on, not having to tell you what is going on, somebody who is interested in doing their job and sees no legal reason to tell you why they're looking through your bedroom, why they're looking through your drawers, why they are patting you down on the street. That is so incredibly different. They cannot claim anything different. Okay. Next on this idea of my split, right? Because I'm telling you why it is so incredibly important that public perception is harmed on their side of the house. This is going to be linked to that, right? Because note that the difference here is that when you believe that the police can pat you down at any time, when they can stop you in the street, search your body, when you believe that when you're sleeping in the middle of the night, they can walk into your house, bust down your door with no reason, what does that lead to? That leads to an incredible fear of police. What are we seeing in the USA right now? What did we see during the Dawn raids? What is the link here? What did we see when the Nazis were breaking into people's homes in World War II? The link is that people do not like it when they're able to be questioned by police, when they're able to have police force on them without their knowledge, without their consent, without the knowledge that this has gone through the courts. The difference is when you believe it has gone through the courts, you have that trust in the legal system because you believe that, okay, there are processes behind this, there are people who have made this decision, they've evaluated the evidence, they've decided this person can come into my house. When that goes away, the public loses that perception of trust in the legal system. You start to see every police officer as somebody who could barge into your house. Note that this is incredibly important and incredibly heightened for minorities who already have that disillusionment with the legal system. When you already know people who you believe have gotten pat down for no reason, when they have gotten no justification for it, it doesn't matter if that is one case out of 1,000, that is enough. When you hear of a friend's neighbor who had this happen to you, you are now incredibly scared of every police officer you see walking on your street. But then two, note that when minorities have this distrust in the legal system, it is just far more harmful because they're more frequently exposed to it, right? We give you tons of mechanisms at Lucy why minorities are so much more exposed to it. This just increases that, right? But then three, note that when the law becomes nebulous, I think this just stands as a separate reason for why people feel scared, right? Because note that what is so incredibly impactful about this new thing, right, is that the law is no longer a written piece of paper that you can point to and give exact reasons to. When the law becomes a police officer's judgment that is based in the moment on the extent to which they believe it is probable cause, it didn't have to go through a court, it didn't have to go through a juror a judge who is like made to make these like very objective decisions. It is literally one dude deciding that I think you committed a crime. I think I have legal right to look inside your house. No matter the extent of the scale of which they can claim here, this still stands. This public perception is incredibly important because we tell you that not only does it impact people, it impacts minorities. It is a prerequisite also for getting any sort of faith or justice in the legal system. Okay, next then I'm going to deal with a quick framing here because they tell you that it's not going to be abused. Police officers are going to use this like very sparingly and they're not going to want to use this very heavily, right? A couple of things here, right? They tell you the police want trials to be successful and courts want it too, and therefore courts aren't going to like it if police officers are currently bringing in this. I don't think they give you enough mechanisms here why the court will not like it if police officers are bringing in this evidence that is now newly licensed under law, right? I think if they tell you that the courts want to use all the evidence available, you have to believe then that the courts don't see much of a difference between these types of evidence. The courts aren't incentivized to then pressure police officers into not bringing in evidence that they claim is going to help put away criminals. This doesn't make any sense. What you should believe then is that this will be abused used by police officers. Why is this? Because they can claim all they want about courts. But the thing is, when a police officer gets to make that decision, that is one person who gets to make a decision that is incredibly impactful on families and homes. That is one person who gets to make this, right? We give you tons of reasons at Lucy why police officers are uniquely exposed, like why they're uniquely exposed to bias and why they are uniquely likely to have bias towards minorities, right? This literally looks like on the ground when you have over-policing in areas that have a lot of crime. It looks like these police officers, whether or not you want to believe they're like racist, when they see a lot of people in these areas who belong to a certain minority committing crime, this reaffirms their belief that, oh, these are the neighborhoods that commit more crime. This reaffirms their belief these are the people who commit more crime. This means that when they see someone walking on the street who looks like that person they've seen commit so much crime, and they believe, oh, I think maybe you have drugs. I think this person has told me you might have drugs. That is enough cause for me now to search your body. That is enough cause for me to pat you down. That is what we're talking about here. That is the change that you actually get. Next then, on their push here, they're going to get more criminals in court and prison faster, right? Know that this is their main substantial push. Firstly, I want to note that I think when they say there's going to be murderers, I think this is relatively uncharitable, because I think when you have such high profile cases, such high burden cases, these cases are ones in which the court will literally do everything possible under the legal system to get the proper evidence, because they are aware of the massive bad public perception that will come if they're just letting murderers walk free, right? They cannot come up to you and claim that murderers are currently walking free in the status quo willy-nilly. I think this would just result in massive media headlines about murderers not getting there. I think this is just very easily sense checkable, that generally when we have these massive crimes, they are getting prosecuted, right? But then two, the reason this is not going to happen is because note that the people they're trying to claim here are the people who are on the tipping point of courts being able to prosecute them or not, right? What's going to happen here is that lawyers are going to lawyer, because lawyers are only going to lawyer for the rich people. What a lawyer can very easily do in court then, when you have this rich person who's gotten off on this crime, is a lawyer can very easily argue why this was not lawful grounds for this evidence to be unlawfully obtained, because there are still obviously some grounds for which they have to claim. Lawyers can very easily get around this when the law is so nebulous. Minorities won't have access to this. You're going to have access to your tired, overworked public attorney who is not going to be able to do this. But then we say that even in their absolute best case, right, and I'm going to flag that this is responsive to their deterrence point that they bring here, right, because I think for the criminal, being in court and being in the legal system to the point at which the court is on the tipping point of whether or not you're guilty, that is enough grounds for that criminal to have that deterrence. That is enough grounds for them to be oh, you know what, I'm not going to commit crime again. Note here too that a lot of the crime they're talking about are violent crimes that are committed in the spur of the moment. They were committed irrationally. They were committed emotionally. These are not the crimes that people plan and do in premeditation, right? This means that the deterrence point just doesn't stand here, right? Now quickly then, on to victims. They tell you that victims are very traumatized and therefore this is going to give catharsis to victims. I already tell you before why agency is a prerequisite to any of this. But then two, we said that the trust in the legal system is just so nebulous on our side of the house and on their side of the house, and because you never have that inherent trust in the legal system, when you see every police officer as someone who could harm you, even whatever they do to the criminals is not going to help. But then even in their absolute best case, we just weigh this against the entirety of the population, especially the minorities, who just feel so disadvantaged, they feel so disenfranchised, they literally see every legal enforcement officer as someone who can harm them at any given point. That is incredibly impactful. You should care far more about that.
I thank the speaker for their speech, and I now invite up the second speaker of the litigating team.
All rise for the Honourable Judge. We find the affirmative team guilty of fear-mongering, exaggeration, and just being plain wrong. Now, I have 3 points for you in my speech today. First of all, to address their major push on the fear of police. Second of all, to address the idea around the real principles behind what we give courts the jurisdiction to do. And third of all, to address how this plays out when it comes to serious crimes. Now, let's start with their main push of fear of police, people believing that they can be arrested at any time. I think, first of all, we give you the clear incentives on individual police officers not to exploit this system. These are never responded to. Police officers don't want to lose their job because they bring in people with inadmissible evidence all the time and the department sees them as a liability, or because people keep saying, hey, if you keep pairing me with this guy who brings in inadmissible evidence, I'll never get any of my cases through. Get him out of here. I think there are many incentives on police officers also for their personal representation, for their personal reputation, simply to not gather evidence illegally unless they really, really think it's a good idea. Also, I just want to tell you that the police already have the ability to just tackle you in public if they say you're committing a crime. We already trust the police's judgment to the level of which we allow them to just arrest people and be sorted out later. And this is no different because it will be sorted out later. They would like to tell you that this decision never goes through the courts, but it absolutely goes through the courts, simply after it has been made, like the decisions of most other people in most situations that go to the courts. The goodness of the decision, the consequences of the decision, and whether or not it will be used is simply decided after the decision is made rather than before. It still goes through courts. There's still a legal system involved, and the police know that, and so they have an incentive to be reliable. But also, I just want to say that they say that people will distrust the police, and this is really bad. One, I think migrant communities and minorities who are targeted and over-policed already distrust the police because they're targeted and over-policed, and so they say, hey, that's unfair, I don't trust the police. So I think the extent to which this increases that is kind of just marginal, because even if you hate the police a little bit more, you already weren't cooperating with them. You already felt slightly in fear when you saw them on the street. So I just think the increase is not as large as they would like to tell you. But I think the main thing when you're talking about trust is you have to imagine how victims feel when you suddenly tell them that if they testify in a violent crime, if they testify against the person who attacked them, they stand the risk because of one police officer's mistake, because the warrant came through a minute after they walked into the house, because the criminal hid the weapon just over a property line and they didn't technically have the warrant for that property. That witness now stands to the chance of being killed or assassinated or intimidated by the person who is then let free by the system to wreak their havoc. I'll take your point because you're insistent.
When you claim that courts have the incentive to use the evidence, and we give you reasons why police officers want to arrest people, why do police officers not have an incentive to use this evidence when they want?
Okay, because the police officers lose personal reputation. If they're always in the court using inadmissible evidence, the court is eventually going to fed up with them. There's always a chance that the court rules that the evidence isn't key anyway. There's always a chance that they still face consequences, because here's another thing they've told you that's simply not true when they try to tell you there's going to be dawn raids, okay? We're not legalizing police brutality. Everything the police do that was illegal then is illegal now, with the exception of the fact that if they gather illegal evidence, that specific evidence is now admissible in court. That means if police commit crimes, they are still found liable. If police grab you and drag you out of your house with zero probable cause, they will still go to jail. If police set up a dawn raids club, they're still wasting away in jail till the end of their days. We are not legalizing police brutality. We are simply saying, okay, well, we've got a bunch of evidence and it's the court's responsibility to consider all available evidence, so we're going to use it. Note as well that this is in the case of these really extreme crimes. So police officers who are mostly in their day-to-day dealing with crimes like larceny or littering or, I don't know, harassing people in public or public nudity, or speeding, simply aren't going to be using this that much day-to-day. It's when they suspect someone of a serious assault with a deadly weapon. It's when they suspect someone of a sexual assault. So one, this happens not that many times, and so the scale of fear is very low, unless like someone you know was involved in an assault and you really, really hate police, but we think that that's the same on either side. And also, it means that the extremity supports our material when we tell you that if you let these people go free due to a small mistake, there's an extreme risk. So that's their point of fear of police, and I think at the end of all that, I tell you that we can just outweigh it. Why? Because the principle they tell you is inviolable. The principle that we absolutely have to put above everything of this freedom is not actually what we put above everything. Why? Because we already go against, public principles and general civic principles when it comes to ensuring one overruling goal, that the court has enough evidence, that the court has fair and reasonable evidence that it can consider in its trial to make the best decision. We allow the court, for example, to invade people's privacy, kick down their doors, etc., simply with prior consideration. Why then can we not consider after the fact, in very extreme cases, when time was of the essence? Consider a situation where you believe that the person is about to destroy the murder weapon or flush it down the toilet in the house. You don't have time to call up the courts. You have to make a split-second decision. And so if police officers know that they are never safe making a decision that could save lives like that, they will never do it, or the evidence will not be admissible, the murderer will get away, people will die, victims will never feel safe to testify, cases will fall apart, and criminals will continue to run free. So I think it's just simply obvious that this unimpeachable freedom, they tell you, doesn't exist, and that in society we already afford the courts the ability to make a decision on whether or not they are allowed to violate our privacy. Whether this decision is made before or after the fact doesn't necessarily change that much when we think that we're dealing with extreme scenarios, when we give you incentives why police officers are just really unlikely to do this all of the time, and even just at a baseline run into these kinds of crimes quite rarely. And I think it just becomes clear that this principle can never outweigh the harms to victims we give you, which look like being in fear of your life, not just in slightly increased fear of the police you already hated, which looks like not testifying in a case that allows someone to go free, not even because there's inadmissible evidence, but because you're worried that somewhere along the process a police officer has forgot to number an evidence bag correctly, and suddenly the person who you just testified against, Ted Bundy, is back on the street and he's after you, and he knows your name, he knows your address, he's coming for you. That's terrifying, and those are the kinds of exaggerated scenarios that appear in people's heads when they have this concern. That's the kind of fear that people are genuinely under when they're already vulnerable, when they've already suffered from a crime that is only compounded by this fear, compounded by the ability they give for criminals to run free because of small mistakes and legal loopholes. We simply think that when you're dealing with extreme crimes that we characterize to you, when you're dealing with sexual assault, when you're dealing with potential domestic terrorism, the state must have a right to justify something in reverse, like every citizen has a right to justify their actions in reverse in a court of law. It is a transversable right. We see that already we agree with the principle that the state can invade our privacy in some situations. We see that obviously we have won the debate.
I thank the Speaker for his speech. I now invite up the third affirmative speaker.
our claim was simple, that we protect the most important people, that we protect the most people, that we protect the people that did nothing wrong, that were never involved, the ones that wanted to maximize their happiness, that wanted the choice. We wanted to protect the people that they stripped their rights of. We wanted to protect human dignity. We wanted to protect humanity. I'm going to do 3 things in this speech. I'm firstly going to talk about the principle and why it's the most important thing, why they could never win on this. And then I'm going to talk about justice and protection and why it actually gets a lot worse on their side and how they tried to straw man our argument. And then why, even if the ballot is that close, why you should give it to us on the minorities and why that's debate winning, why that's really good material. Now onto the principle. They had a lot of claims here on the principle and they tried to watch this out at the start because they knew this would be a big push. I never think they did this sufficiently. The first thing they said was that on our side that you have search warrants and that also invades on your right to privacy, therefore it should be justified in this cases. We already gave you the reasons at Krisha. Michael never responded to them. He never added nuance on why it's actually the case. Those responses still stand. But I think an additional reason you should buy this is just the fact that we are able to infringe on people's human rights when we think there's a reason, when we think it can help other people. They never get that certainty on that side because we told you these are the cases where it's very uncertain and there's not enough evidence that's actually justly found, that's properly found, and therefore you have to go to this improper evidence. They never get that likelihood or certainty. You can never infringe on people's rights to privacy on our side. That was never enough. But I think they next told us that the government has the obligation to protect people from the worst kinds of crime and that you get like victims getting hurt again. I'll deal with that practical later. But I think we have a few really crucial responses. We tell you that this is practically contingent at the very top level. It's contingent on the fact that they actually protect the criminal. We tell you that we can do that on our side anyway, because if you buy the urgency, if you buy that they care so much, these police can go to the crime scene again just in proper ways. That exists on both sides. I'll deal with it later. But I think you should also care about you shouldn't buy the government obligation to protect people beyond the fact it's contingent, because it's prior that you care about privacy, that you care about people's choice, because that is the most important thing. It's logically prior to anything that they can claim, because if you don't have the choice, you can never do anything else. But I also think you should care about the scale, because they give you all of this rhetoric that you should never buy, because we are the side that exclusively actually cares about the people outside of the traumatic case in their best case. We care about the people that the government has the most obligation to, because they never went against the government. These are the most important things. I think, though, what was our positive push on here? We told you very simply that our claim was that you infringe on people's right to privacy at the point where you improperly go onto their land, etc., and do these things. The best attempt that we got from negating was that they tried to outweigh it with these other obligations. We told you why that wasn't sufficient. We told you why it was contingent and that in their best case it was never enough. But I think you should care about this privacy principle so much, because you are literally stripping people of their choice. You can never outdo that. You are taking away people's humanity. That is the thing that's logically prior to anything they can gain on their side. I'm going to prove to you why, even in their best case, if you stop these criminals, why that's never enough. They never expanded on the outcomes, why that was never enough to win that debate. Now onto the justice and prosecution. This is where their main case landed, and they tried to say that police in the first place will never overdo because they don't want to lose their job. But I don't think this deals with how they internalize it, because if you're a police officer and you've seen how court cases go with improper evidence and you're a police officer, you want to serve justice. That's probably why you became a police officer. If you know that court cases actually care about this improper evidence, you will do whatever you can to stop these extreme cases, because they give you analysis. Great. If you buy it so bad, police officers will do it, even if that loses their job in the worst case, because they care about these people. But I think secondly, that's just not how the police works. Police, even if you shoot someone, you are on suspension, you get a lot of you are allowed to put your case forward. They have a shortage of police officers. You can't just say you get fired. That was never enough for incentive if the police cared about the people. But on a deterrence, we told you irrational. We told you that they're not thinking in the first place, so it doesn't matter. You got the all at Krisha. They never added nuance. That still stands. But I think we tell you that they never get faster prosecution of criminals. We have 6 reasons for this. Firstly, we tell you that if you buy their characterization that they are such violent crimes, we tell you that there's already good evidence in the first place, because they tell you that it's so traumatic. We tell you that the victims care so much. If that is true, the police can go back, they can go legally, they can create these warrants. If they care about that, they can do these things. That is not, we have that agency on our side. The police can do that. But I think secondly, if we are humans, you care about our principles. principle to privacy, you care about our humanity. That means that the jury is far less willing to side with the court when they have used improper evidence, when you've been told that you kicked down their door, you took away their right to privacy in the middle of the night. That is something that people connect to on a very human level. But I think thirdly, what the implementation looks like, and listen up, judge, because this is where we flip all of their impacts. Because if criminals know that you can use improper evidence in court, it looks like them trying to cover their tracks more because they know that anything can be used against them. That is very bad. But notice, this means that if they try to cover their tracks more in any case, it also means that you cover their proper evidence more as well, because it's a knock-on and they're just more subconscious and scared in the first place. That means on our side that we get the full proper evidence, and that evidence is far better on our side compared to when the improper evidence is taken away because criminals care so much. I think fourthly though, we tell you that lawyers and bribery is symmetrical on both sides, and that the rich criminals on their side can get away because the juries, there are a lot of issues in the criminal system. But importantly, the nuance is that the poor cannot afford this, they cannot get the best lawyers, they cannot bribe the people. This is where you get the most harm because it means you reinforce confirmational bias. You show people that the worst crimes that they're talking about are committed by people who are poor, by people who may be a minority. You are meaning that boy in the class who is from a minority is now hated on, and now people in this class go on into life with these really bad views. That is something they have to deal with. But I think fifthly, you get more ground for refutation in the court when you use improper evidence. The system is stretched out. It just takes a lot longer. It was never faster on their side. We can get warrants in time in which they have to justify using the evidence. I think sixthly though, in their best case, we proved to you why the principle is just so more important. I'm going to do the weigh-in now. Okay. In their best case, let's say that they get the criminals prosecuted. Let's say that is something that they do. What do? We get the principle of privacy. We get minorities. But let's say we just get principle of privacy because that was non-contingent. That was our worst case. Why was it never enough that criminals on their side were persecuted? Because if you look on the ground level, these victims are never harmed. I'm going to prove that to you. There were no practical benefits on their side because we tell you that if you were prosecuted in the first place, these criminals were never going to do it again anyway. There was no harms that they tried to make out that was mutually exclusive. But I think also that these police care a lot. They're going to save lives either way. These victims are not harmed. That was never enough. The principle was the most scalable thing. That was what we proved to the most certainty. I think on victims though, because they try to tell you that you just get assassinated if you attest against these people. We tell you that these criminals know they're acting under the law. If you've just been through prosecution, you're getting watched more. Even if that's not true though, you internalize it in that way because you're probably irrational. But I think if you buy their analysis secondly on the fact that victims care so much, they likely go back, they probably try to get that evidence themselves. But also notice that police on our side have agency to create search warrants. That was nothing, that was never exclusive to their side. We could get it. Okay. Let's say that this ballot is very close. Let's say that you don't buy any of this and that it all washes out. Why do we still win? Because we told you that we win on the minorities. Because the best they could do is mitigate. They told you that the minorities probably aren't that harmed. There's a lot of things happening anyway, so you get a lack of benefit. I think this is enough though, because you care about the vulnerability. We told you why that person in class from a minority is now getting hated on, and that these people go through biases. Auckland White is right.
When a person commits a serious violent crime, they revert to animalistic instincts, which are morally repugnant, and they lose their humanity and every single right that comes with it. That is to say, in this debate, we place no value on the principles concerning the criminals. We care about the victims. We care about the rights the victims have. We care that the courts have a principal obligation to protect victims. Never been prouder to negate. Okay, 3 things to do in my speech. Firstly is on use cases, proving why the use cases on our side of the house are incredibly limited only to the most essential purposes. Secondly is on addressing the principle, and then thirdly is on public safety. Okay, firstly on use cases, what do they tell you? They tell you that these unjustified searches are only used in nebulous cases and only used in poor examples. I think the thing to explain here is that police officers only use this form of surveillance in cases where the suspect is highly likely to be found guilty. This is firstly, obviously, because there is intense criminal and civil liability to illegally surveilling people. We see cases in the United States where police officers are literally found liable of hundreds of thousands of dollars. I don't think the police officers personally want to risk that. But secondly, is because it has to be signed off by bureaucrats in Wellington who have no personal incentive for finding these people, for dealing with these criminals. Their entire job is assessing the validity of surveillance claims. They are incredibly risk averse because that's their purpose. I don't think they want to sign off on unjustified uses of searches. But lastly is because when you search, when you obtain this evidence, you have to get the permission of lawyers. These lawyers are very trustworthy. They place great value in the reliability and I guess the stability of the court. They would never want illegal evidence to be collected or obtained if the court didn't want it. This means that when the police collect evidence, they are almost certain that the criminal is guilty, and the criminal almost certainly has at least a small amount of liability in this case. I think the only push that they've been able to give you in regards to when this surveillance happens is to say, well, maybe we push it on some low-level offending. Note, firstly, I think the risks, because I've told you how reluctant police are to use this technology, they just do a necessary way-up, which is to say the risk of using it for these low-level cases probably doesn't justify it. Secondly, obviously, the motion states that we are prioritising only the kind of, really severe cases. I don't think they're going to make a ruling on those small ones. So I think that addresses the use cases. We only use this technology where it needs to be. Now on the principles. Firstly on, why not?
When police already have the ability to enter urgent active crime scenes and none of your points of preventing those crimes stand, how do you claim you reduce crime at all?
Well, look, I'm going to address that later, but I think that when police enter those crime scenes, oftentimes they go inside buildings, and they probably should technically have a warrant to do that on your side. I think they justify it by way of saying there's an urgent need, or there's no other way of collecting the evidence as they do on our side. Anyway, on the principles, the first thing they tell you is the principle of privacy. Note, maybe at their best case they prove to you why we shouldn't illegally surveil, but they never actually prove why the courts making this decision not to value the evidence is uniquely enough for this illegal surveillance to stop. Because, as I previously told you, there is a ton of incentives against the police officers doing this illegal surveillance in the first place. So I would suggest that if they make the call to ignore this incentive in the status quo, they probably just do the same on your side. It's unclear why that is enough to uniquely stop it. I think that... So I don't know why that blanket rule is sufficient, especially when they only do it in cases where it is absolutely necessary. I think the next thing they tell you is on the principle of state power, that because governments have immense coercive power, they should be checked and balanced. Note that firstly, as we told you, the government obviously already has a massive principal obligation to protect the victims and people at risk of having crimes committed against them. But I think secondly, note that the state still has that check on power, as we told you at Michael. You still have to go through the court system and justify why you chose to collect that evidence illegally. I think there's usually great media scrutiny to that. There's a ton of awareness, and I think what that means is that there is certainly a check on state power. But lastly, note that regardless of how you feel, it's really unclear to me why you care about the rights of these criminals. Because as I flagged in my setup, when people commit a violent crime, they revert to an animalistic instinct which is reprehensible. They lose their humanity and every single right and responsibility that comes with it. They do not have a right to privacy. They do not have a right to claim trying to get state power. But lastly is what we told you at first and continue to, address down the line, which is that regardless of all of that stuff, the courts have a principal obligation to protect victims and to punish criminals. We've given you all the mechanisms for this. So I think the more logical thing for the courts to do would just be to say, well, we'll take in this evidence, but we'll also create a bad judgment to the person who illegally obtained it. I think it's incredibly harmful and unjustified to ever just say, we're not going to accept the evidence because you diminish the rights of the people who had the crime committed against them, who have a right to be listened to by the court and to have their evidence heard. Obviously, you weigh that far more highly, firstly on scale, but secondly is because the people who use the court system are immensely vulnerable. They made no decision to be going through the courts and to have their case heard. I think obviously you weigh that far higher than someone who probably in any case decided to get involved in the criminal world in some case, whether or not they were uniquely guilty of this one. Now, lastly, on public safety, what I'd like to push to you is that this is an independent pathway to victory, not reliable on the principal stuff. I think that the general gist of this is that they never responded to the kind of case for the general population that they remain safe when we, in any case, just prosecute and accept this evidence against dangerous, violent criminals. I think that all they were kind of able to say is that maybe it scares minorities or it builds distrust. But I think the reason why minorities are distrustful of the police is not due to what they tell you, but it's because the fact that they don't trust the justice system, because so often they go through it and they report crimes and it just goes unresolved. They have to sit through giving testimony after testimony only for the case to be thrown out because there was never sufficient evidence. I think on our side that evidence does exist and it's admissible, so obviously the sense of, trust within the justice system increases, and that's incredibly good. But additionally, note that most people do inherently believe that they're a good person. They probably don't believe they'd be the ones the police would pick on, so I think that they probably don't necessarily feel unsafe by the idea of the police having more impact. Obviously, we weigh the idea of pursuing the justice strongly and accepting this evidence very highly because these victims of crime are uniquely vulnerable. And note that oftentimes there is zero other way of getting this evidence. They say you can just get witness testimony. Witness testimony alone is not enough. Oftentimes witnesses are afraid to give the testimony without feeling as if there's something substantial behind it. The criminals don't care. They're irrational. They harass the witnesses even though they shouldn't. At the end of this debate, stand on the side of victims. Proud to negate.
We tell you that when you are a victim of sexual assault, we tell you that when you go through an entire process of standing up in front of a court of law to prove and to put a criminal behind bars, we tell you that when you have gone through this entire process, with a massive process, overcoming the trauma, to share this with the public with the hope and the knowledge that someone will be held accountable and that you will get catharsis for the wrongdoing and the crime that has been committed against you. We tell you when all of that falls apart because there was a piece of evidence that hasn't been obtained properly. We tell you that whenever that happens, we tell that there's an immense harm. the AF team have to stand for. We tell that is not acceptable. We tell that in no way can that ever outweigh, and that can never be outweighed by any other principle or anything else. 2 points in this debate. One, on our public safety, which we value so highly. I'll explain to you a bit more why this is the case. And then secondly, on the principle of privacy, and how we actually don't believe we violate, how we don't value this as highly. Also, we just don't believe we violate this principle either. So what do we give you? We give you, at first, a lot of evidence as to why we believe that we are going to be able to reduce the harms to public safety, why are we able to reduce crime that happens. We believe, firstly, we tell you the evidence that you're likely to get is key evidence. We tell you, secondly, you're likely to deter criminals from being able to abuse the system, to exploit loopholes, and thirdly, we tell you about, again, those victims who, when the criminals do end up walking free for these reasons, face the trauma of having these people on the streets with them, going into the same stores as them. We tell you that the harm that these victims face. Note that these victims who have had the primary principle and the right that the government had for them to do to protect these people, when that has been failed, it is important that we care about these the most. What do we get in response to this? Really, the only response we get to this is like lawyers are going to lawyer and that they're going to be high profile. But again, we tell you throughout our case that this is the key evidence that you honestly cannot out-lawyer. This is the decisive evidence that you need. What else do we get from the affirming team in this case? They tell us that you're going to lose trust because of dawn raids. But we give you so many structural reasons as to why we believe that police officers are going to act properly and do the correct thing in these situations. The only thing we get from the affirming team is essentially, they're just irrational actors every now and then. We don't believe this is the case. We tell you that what they do reflects on them. We tell you they want their case to go well. We tell you that they want criminals put behind bars. We tell you they likely believe in the law, believe in justice based off becoming a police officer. We tell you they also just face consequences for their actions. You cannot do a dawn raid. If you do a dawn raid, you will get put behind bars as well. We tell you that, therefore, you're unlikely to get all these dawn raids. On the point about, the trust that you lose in minorities, we believe it's far more likely that when, the key piece of evidence that you now have and can apply in a case that a minority group brings against someone, but the rich person or the person from privileged background can out-lawyer all the other evidence. When we have this key piece of evidence they can bring there now, you're far more likely to trust the legal system and the justice system because of these reasons. We weigh this so much more highly because we have criminals off the street. If we just get one criminal off the street, we tell you that when we get these people that no longer commit crimes against all of us, when we get the catharsis and the redistributive action against these people, that is so massive. And I gave you the reasons and I told you why this is the case. On the principle of the privacy and on this evidence as well, we get from the affirming team that there's a principle of privacy that you ought to care about in this debate and the principle of state power. We tell you this is not the case. We tell you firstly that we don't violate this principle. Why is this? Firstly, we tell you that just like you can justify these actions after these things happen. We tell you that we afford the same rights that a lot of citizens get as well. We tell you, secondly, that we see, through an intuition, we give police often the same judgment calls. We trust police to do these things. We just apply this and we suspend these liberties very often. We now just apply these things and suspend them and allow police to do them as well. And then Bryn also gives you the material about how, because we believe there's a chance these people are guilty, they forego their rights. And we just believe, even though at the end of the day, even if there is the principle violated, we care so much more about the trauma. We care so much more about the tangible impacts that are affected. And that is why I've never been prouder to negate.
I think we can all agree that if a stranger raids your house at the middle of the night and pins you to the floor and refuses to reason with you, that is principally abhorrent. 3 things to do in my reply today. Firstly, I'm going to talk about victims and coming to an outcome. Secondly, on accused offenders. Lastly, on the societal implications. So firstly, in terms of victims and how we get to an outcome, I think this is Wellington's strongest push, and they tell you about how you help more victims because there's just more evidence, and therefore this leads to a lot of change, right? And note here that the amount of change they're able to claim on their side of the house is quite minimal, and they never scaled these impacts. 1, the police can search crime scenes symmetrically on both sides of the house, and you prevent crime the moment symmetrically, right? If someone was killed and there is a knife and there's a scene there, police and forensics will search it symmetrically. But 2, if it is blatantly obvious that someone has committed a crime, it is really easy to get a warrant to search them anyways. If, you're looking at someone who is associated with 10 missing people, it is incredibly easy to just go to the police and say, okay, I'm getting a search warrant, and it's probably going to approve this warrant in the first place. They're lying to you at 3rd when they tell you that you need to send this warrant out to Wellington and get it approved by the Prime Minister. What the hell? But note there, if someone is linked, and note here that these people just get searched anyways, they get warrants. It is pretty easy. And note here that on their side of the house, for illegal searches to happen, the police have to say, no, you cannot search this person's house because it is highly unlikely that they committed this crime. This person is likely going to be innocent. But 3, it is just speculative as to whether or not illegal search warrants will actually find evidence and thereby benefit victims in the first place. Maybe you can conduct 500 illegal searches and only 1 is successful. It is 499 violations of the right of privacy. Maybe you never find anything. It is unclear as to what it does for victims. In the majority of cases, this is used. But 4thly, they tell you about how justifying obtaining illegal evidence in court. It's very unclear as to what this actually looks like in the court procedures. Presumably, it's very difficult to justify busting down someone's house before you know someone has committed a crime. This means the court process of doing this is probably going to take very long. We just weigh it against the time it takes to get a warrant, largely symmetric. But secondly, in terms of accused offenders, this is where our principle lies, and I think it still stands. It received very little engagement because it was independent of any tangible mechanisms that they gave you, right? But secondly, even if you are 80% certain that this person is guilty, it is never absolute certainty. And this means that in all instances of illegal searches, you are potentially searching an innocent person, you're potentially violating the rights of this innocent person. But 3, sure, the evidence that is shown in court, which was illegally obtained, this person is proven guilty and thrown into prison, we would still weigh this instance as principally abhorrent. 2 reasons. A, because we principally value proper process of justice, right? It is analogous to why you cannot just preemptively arrest people on the street. Even if they do end up committing a crime later on, you do not do this because you are not certain that this person is going to commit a crime in the first place. But B, in terms of proportionality, when you violate someone and you go into their room at midnight, even if they're convicted, their sentence is going to match the crime. You do not want to punish people more above their sentence, right? Lastly, I'm going to whip racial profiling because one false raid is enough to incite fear for minority communities. Because even if you're already distrusting of the system, it is the difference between avoiding someone on the street and having this person loom over you in your sleep at midnight. Obviously, that is absolutely massive. The margin of change, the fear this incites is really huge because it is the person who is actually in your personal space now. It is a person who does not respect your rights. It is a person who is actually a threat to you because you have no idea why they're standing by your bedside at midnight, right? And note here the societal implications is incredibly important. We give you tons of reasons as to why society's perception of the police turns into fear, why people trust the criminal justice system less, because people, the system follows the law less, people trust the law less, people trust the system less. For all those reasons, let's not kill innocent people.
Congratulations all. I invite you to cross the floor, shake hands, and then head outside. As a reminder, this is a silent round, so you will not receive an adjudication, a result, or anything. So get out of here.